morning. Today is November 13th, 2025, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong Motin. Every Thursday, Jean Lawler, David Shraga, Michael Schwimmer, and I host another cutting-edge program for mediators, arbitrators, lawyers, and everybody who negotiates. There's no charge for these webinars. Rather, we ask you to contribute to a food bank if you like what you see. And since we began the series in 2020, our audiences have been so generous in contributing in honor of our great speakers. One of my favorite, and I think the best parts of the webinar each week is when we announce the running total of just how much our generous audiences have contributed. Jean Lawler, would you please do the honors?
With pleasure, as always. Good morning, everyone. Good afternoon, good evening, wherever in the world you might be. It's great to see you here, and thank you so much for your generosity. As of last night, I guess, we had been told of donations to food banks around the world of $893,371.66. I mean, that is millions and millions of meals. It's just unbelievable how this grassroots project grew, and we're going to hit that $900,000 number soon, and I can see $1 million just down the road. So thank you all so much for your generosity.
Fabulous. Thank you, Jean. And this week we have another great presentation. Jim Murray, chair of the Insurance Recovery Group at Blank Rome LLP, will speak to us on the mediation of national complex insurance coverage cases. When corporate survival is on the line, insurance coverage becomes more than a contract dispute. It becomes a high-stakes battle over risk transfer, financial exposure, and long-term business continuity. In these bet-the-company insurance coverage cases, mediation can serve as a powerful tool, but only when used at the right time and in the right way. Drawing on decades of experience negotiating with the world's largest insurance companies, Jim Murray will explore how sophisticated parties leverage mediation strategically in large-scale coverage disputes. Jim Murray leads Blank Rome's policyholder-only insurance recovery practice, formerly the insurance practice of Dickstein Shapiro LLP. Jim is the only policyholder trial lawyer in the country who is a fellow of both the American College of Trial Lawyers and the American College of Coverage Counsel. He has litigated cases in 24 states for top-tier corporate clients and has represented individuals as well as an array of religious institutions and government entities. Jim has been ranked in Chambers, he's ranked in the National Law Journal, and Lexology for 2022 through 2024. Lexology named him the exclusive winner of the Client Choice Award for Insurance and Reinsurance for the USA. Finalists can only be nominated by corporate counsel. Jim clerked for the Honorable James Hunter III of the U.S. Court of Appeals for the Third Circuit from 1981 to 1982. He was special assistant to William Webster, director of the FBI from 1983 to 1985. He's a Rhodes Scholar. He was raised on a farm and a ranch in the Fort Peck Reservation in eastern Montana. He plays folk and country music when he has the time, and for many years catches the occasional gig with his brother in their Northwest band, Smoke Creek. Boy, that's really something. Jim Murray, please tell us a little bit about the food bank to which you'd like people to contribute if they are able, and then on with the presentation. The floor is yours.
Thank you very much, Jeff. It's a delight to be here this morning. I really admire this organization, this effort. So my charity is Bread for the City here in DC. And by the way, I just heard construction starting out my window. I apologize. I hope it's not the West Wing coming down. I don't think so. But in any event, Bread for the City is more than 50 years old. It was formed by a group of DC churches to make sure that the poorest families in DC had food and clothes. And it's perfect timing, a couple weeks now before Thanksgiving, because one of the annual events that Bread for the City undertakes each year is to try to ensure that no family in the District of Columbia doesn't have a great Thanksgiving. And this year, they intend to distribute more than 17,000 turkey dinners, all the stuffings, all the fixings, to poor families across the country. So perfect timing. So thank you, Jeff. Let me say a few comments this morning. I'm really looking forward to the questions. It's a pretty sophisticated group. And as I told Natalie before everybody got on, it's a little intimidating to come on after people like Ken Feinberg have given these kinds of presentations. But let me say first, I really admire the work and the temperament and the skill of mediators over the years. Many have become good friends. Some are appropriate for certain cases and not others, but I do admire the work. Now, having said that, I have some confessions to make. One, I would be an absolute terrible mediator. I would blow up by 11 in the morning and I would tell all the parties to go to hell. So no competition from me in that regard. Number two, this is a little bit deeper confession. I really hate mediations. I tell my clients at the beginning of the day, if they haven't mediated before, you are about to experience the most exhausting and tiring day that you will have, while at the same time basically doing nothing. And there's a lot of truth in that. I find myself more spent, if you will, at the end of a day of mediation than at the end of a trial date. And so again, that said, I'm a trial lawyer, and by definition, I am a mediation participant constantly, especially in the last 20 years. And then finally, the third confession, I'm pretty sure that I will say nothing new to you today. At least I will not raise any topics that you have not only heard before, but thought about and discussed before. So now that I have your attention for a very scintillating and new conversation, let me say that I do think it's always important to hear slightly different context on the same issues, choice of mediators, for example. Context to me, I think as you get older, you realize how important context is, how important viewpoint is. I sometimes feel that my adversary in a mediation is delusional, and sometimes I'm correct, most times I'm wrong. But the importance of context, I mean, you remember General Custer's last words at the Little Bighorn. Men, we've got them right where we want them, because now we can fire in any direction. So Custer was delusional. He didn't think so, but he was, and we rely on you mediators and the mediators on the call to tell us when we're delusional. Now, what I'd like to do today is talk a little bit about my perspective as a participant over the last 40 years in many hundreds of probably thousands of days of mediation in large scale, mostly insurance coverage, but other cases as well. And my perspective in particular, I'm going to talk today just to try to have a different little bit perspective, mostly about some Chapter 11 bankruptcy insurance cases that I've been involved in over the last 20 years. So, but generally I am a trial lawyer. My trial practice is largely just fighting insurance companies. It started about 40 years ago when, as a junior lawyer, somebody senior to me by 3 years walked in the library and said, "Hey, Murray, that Boeing has this environmental issue you've been working on, but now there's an insurance issue." And my response was, "I ain't doing that. That sounds really boring. I never took insurance law, wouldn't take it. I don't even know if it was offered." He said, "Well, one, you're doing it." In those days, that was the way we were told to do. But secondly, Murray, you came to a big law firm in Washington, D.C., and you want to be a trial lawyer? You think you're going to try an antitrust case? You're 10th partner on an antitrust case? Do you think you're going to try a First Amendment case? If you want to try cases, the most likely possibility is to be fighting an insurance company, especially on large scale companies. And I still use that speech to new lawyers today to get them into my group. And this becomes relevant to many of the mediations I've done. Most of my career suing insurance companies has me living in the past. Probably 50, 60, 70%. because most of my life is pre-1985. Why do I say that? Becomes relevant to the mediation points we're going to make. In 1985, the insurance industry hit a very, very hard market. And it was no coincidence that in 1985, 1986, there was an absolute pollution exclusion, an absolute asbestos exclusion, and an absolute sexual molestation exclusion put into the policies. Enough was enough with American juries, said the insurance industry, especially Lloyd's of London. So they thought that would probably end much of the battle going forward. So three things happened, of course. One, Congress enacted Superfund, which a company that dumped waste in 1895 at a manufactured gas plant all of a sudden is liable for that action 70, 80 years later. A asbestos claimant who inhaled a fiber on a submarine in World War II, but didn't start coughing until 30 years later and discovered that. Statute of limitations was told. And then, of course, in the last 5 years, probably the biggest issue, and one that I'm going to talk about mostly today in the terms of Chapter 11, many states in the context of child sex abuse have either opened windows, meaning they've gotten rid of the statute of limitations for a set period of time, or they have opened it entirely, or like many states in the Northwest, like Oregon, Idaho, Washington, there is a manifestation trigger, meaning if a victim was abused when they were 7 years old, but they only just realized that all of their life's issues were a result of that abuse at age 70, the statute would begin to run then. And that's a factual issue that would go to a jury. So good luck on that. So all of a sudden, the sexual abuse area in the last 20 years has really become the third front and the third wave of historical claims that challenge us to live in the pre-1985 period. Now, when Jeff asked me to talk about this topic, first thing I thought was, what does it mean to be a complex case or a large case? Obviously, a large case could mean a lot of money, but is that necessarily complex? So in the World Trade Center dispute, the issue was, put it simply, whether there were one or two occurrences under the policy. There were separate limits for each occurrence, and was two towers that hit by two different planes at slightly different times, two occurrences, or was it one occurrence arising out of the same ultimate cause? What turned on that was $3.5 billion. So the coverage dispute was either $3.5 billion or $7 billion for Silverstein. Issue was kind of simple. It ended up going to a jury simply because the nature of the policy and whether the policy had actually been, and all the terms of the policy had been consummated, became a factual issue about the history of the binder, et cetera, et cetera. But the issue, which we still struggle with in every one of our mediations, is one of the bigger issues, which I'll talk about. Number of occurrences, pretty simple to understand. Or is it difficult legal issues that make a case complex, or a combination? I think of there's a lost profit exclusion in many of the more modern policies, D&O policies. And that's a very complicated issue. It takes a while to make it through, and mediators do a great job at grappling with that. But in the end, that's one issue that's highly complex and millions of dollars a ride on it. Or is it the number of insurance companies involved? Is it the number of attorneys involved? More importantly, in my head, what is the personality of the insurance companies and the attorneys that can make it complex? The very same issue in a mediation with, I don't think I'm going to name names, but I get pretty tempted to do so. But right now, XYZ insurance company, if I know I'm coming into a mediation with XYZ insurance company, I think there's a high chance we might get done. The national lawyers are pretty reasonable. We see each other in the same cases all the time. And the company thinks, from a business point of view. If I see ABC insurance company, mega insurance company, I say right away there is zero chance this mediation is successful. The company's difficult, extremely difficult. The attorneys are jerks, and the mediation is probably not worth it. And so that to me makes the case more or less very complex. And then finally, and again, this is very general, but in terms of really nerd issues on the insurance side, the type of insurance policy dispute resolution provision can really be relevant to the mediation issue and the choice of mediators. And here's what I mean. Many of the historical policies in pre-1986 and still to some extent have no real dispute resolution provision. Even Lloyd's of London agreed to be sued in the United States. And ultimately, those issues are either legal or they go to an American jury. And that's why London got sick of American juries in the mid to late 1980s. So if I'm going into a case where I know at the end of the day, if I don't have a mediation successful, but I'm going to go to a jury, I've got a little more confidence to hold the line. And, the insurance company's always going to talk about the eve of trial, et cetera, et cetera. But flip that to where the dispute resolution and the policy being mediated, and this is often true in the case of the Bermuda Form or London policies, where American industry, to buy $1 billion of product liability coverage, have to agree to these terms. Bermuda carriers, London carriers won't come into the United States anymore. They'll meet you in Toronto, or they'll make you come to London or Bermuda, but they will not submit to jurisdiction. And what does the dispute resolution clause in many of those cases say? It says that if there's an ultimate dispute, it's got to be in London or in Bermuda, and the three arbitrators, private arbitration, confidential, and the three arbitrators must be former executives of insurance companies. So American jury, three insurance former executives. I got different considerations, and the mediator always knows that, not to mention how expensive those kinds of arbitrations are. And then finally, the last thing I would say about, and this gets a little bit into the choice of mediators, arbitration provisions and I'm encouraging everybody to understand, when you go into a mediation that's in insurance coverage, what the arbitration provision or the dispute resolution provision is. We don't do real reinsurance in my group, because to do that, you'd have to represent an insurance company, and we won't do that. So the purchaser of the reinsurance, the cedent, is usually a big insurance company that sells part of the risk to another insurance company, which is the reinsurer. But on occasion, large industry will have a captive insurance company. There's a captive of the industry. And in those cases, there could be a reinsurance treaty dispute. And we have done those. In a recent mediation, we picked a mediator who I highly respect, very, very knowledgeable. And in an ordinary insurance case, I would use him again. But his background was heavily in reinsurance, in the real reinsurance world that I don't live in. And he understood those concepts. I don't mean understand. He empathized with those concepts much more than I did. And the mediation was unsuccessful. In my view, what he didn't appreciate was in this particular arbitration clause, which was pretty manuscripted, the neutrals, the party appointed arbitrators did not have to be insurance executives. They had to be both an insurance executive and a former claims risk manager from a company. It limits the universe in the world to about 30 people out there that have done that. But more importantly, the neutral had no requirement. And at the end of the day, we had a retired federal judge as a neutral. And so the arbitration ended up looking much more like a federal district bench trial than the London arbitration, reinsurance arbitrations that would drive me crazy if I actually had to do those on a daily basis. And we did very well in that. So long-winded way of saying, when it's mediating a reinsurance dispute, in any insurance dispute, I think one thing that's overlooked is what is the dispute resolution provision, because that could determine the case. Okay, so let me make some comments on the topics that you've heard and discussed amongst yourselves many times, but in this context. So over the last 20 years, especially the last 10, I've spent many hundreds of days in mediations in Chapter 11s, largely for bankrupt Catholic entities. Many have been successful. We've had about 40 across the country. I've been involved in about 20 of them, starting back in 2003. And there have been many successful ones that were mediated: Spokane, Washington; Helena, Montana; St. Cloud, Minnesota; Santa Fe, Guam. Syracuse, New York, Rochester, New York, and I'm happy to say New Orleans. On Monday, I'm testifying down in New Orleans at the confirmation hearing for that bankruptcy. All of those mediated. There are about 15 of them still pending throughout the country, San Diego, Buffalo. And there are several well-known bankruptcies that were successfully mediated that were not Catholic. USAG, probably the most significant on that. Two class actions, BB Medical in Delaware and Johns Hopkins here in Maryland, $190 million payout in that case. All of those mediated. Class action is a whole different issue we don't have time to talk about today. But what does it mean to be a complex mediation in this context? There are some unique attributes. I think one, people look at these cases where there's 400, 500, 600, in the case of the Boy Scouts bankruptcy, 80,000 victims, and they tend to think mass tort. So you think of Ken Feinberg and mass torts. But when you think about it, it's not a mass tort. It's not one product. It's not Agent Orange. It's not a defective medical equipment. It's 400 or 500 individual assaults, individual sexual molestations, often different perpetrators, different victims, different levels of abuse. So how do you treat 400 or 500 in individual cases in that mediation? That's number one, complexity. Number two, many diverse stakeholders in the bankruptcies, as I'm sure most of you know. Obviously, the debtor entity. In the case of USAG, it's USAG. In the case of Diocese of Rochester, it was the Diocese of Rochester. But other critical stakeholders in those cases, for example, are the non-debtor parishes who want a release. Or in the case of USAG, United States Olympic Committee wanted a release, even though it wasn't in bankruptcy. And so they had positions and still have positions at the table in these cases. And then, of course, there's the tort committee that represents this class of victims. That committee is usually 6, 7, 8 of the victims who have been chosen. And they are technically the client of the tort committee counsel, who's appointed by the debtor, appointed by the bankruptcy court. That counsel, sometimes both bankruptcy and insurance, to look over my shoulder, make sure I'm not being weak, has their obligation to the committee. But then, kind of the corollary of the parishes, there are a number of stakeholders in terms of the plaintiff lawyers who represent individuals. Out of 400, maybe XYZ law firm represents 30 of them. There are 30 different clients. Their interest is not necessarily the entire group. And all of those have roles at the table. Add to that, which used to be a non-issue, but it's been a real pain in the butt in the last 5 years, is the United States trustee. So obviously since Purdue in those cases, but even before, the U.S. trustees, especially on the East Coast, taken a much more active role. The U.S. trustees actually contesting the resolution that was brokered down in New Orleans on Monday. So all of these stakeholders, that's another complexity. Third big complexity, the damages, the amount of money, the loss. What is it? If I have a fire of a building, or even in the case of World Trade Center, we knew what the loss was. You knew what the loss was. In this case, when you go into bankruptcy, it's usually on the eve of a trial, or it's quickly after a trial, like the Duluth bankruptcy, where they had suffered an $8 million verdict, and the next day we're in bankruptcy. But what is the damages over the 400 victims that are now in this case, if assuming the creditors committee is the main creditor in the case? That is part of the mediation. That is a part of the mediation where both the committee counsel and the plaintiff's lawyers have different opinions sometimes. That is an issue that's negotiated and mediated at the same time between the debtor. What's the debtor going to put in? My view of what the committee usually says is, give us what you got. We take 400 cases to verdict, and it's a hell of a lot more than you got. So subject to restrictions, what do you got? Give it to us. And then, of course, my role is, as we're negotiating this unknown quantity of money, insurance companies, how much are you going to pay? And here are the arguments why you should pay. And so those complexities all at the same time hovering, it's really a three-legged stool between the debtor, plaintiffs, and the insurance companies. It's a real convergence for the mediator of tort law, bankruptcy law, and insurance law. Now, couple positives, I guess, if you will, from in most of the case, I think, frankly, in all except one, and that ended up being mediated. There's no path forward for, say, a diocese other than mediation or dismissal, go back to where you were, 2 or 3 lawyers get a big verdict, and everybody else gets nothing. The only successful path forward is mediation. And so in almost all of the cases on day 2, if not day 1, a mediator ends up getting appointed by the bankruptcy court and given pretty good authority by the bankruptcy court to move resolution. Whole other issue we can talk about lately, more than one mediator have been getting appointed, and it's a fascinating topic. In one case here on the East Coast, 3 mediators were appointed on day 1, one for torts, one for insurance, one for bankruptcy. And we can talk in the questions about whether that makes any sense. And then finally, here is the one positive I think that really is helpful. So insurance companies, as you probably know, will pay more dollars the bigger the release. And normally outside of bankruptcy, the insurance company will say, give us a policy buyback, hell no. Give us a lines buyback, hell no. We'll give you a buyback. I mean, we'll give you a release on this claim. And that's the negotiation. In the bankruptcy, you start with the proposition and the truth that there is going to be a full, complete release for everybody if there's a successful mediation. And it's what I call the granddaddy of all releases. Not only will the insurance companies who are paying money get a policy buyback that's that's brokered by 5 different big law firms to make sure, but they also get a channeling injunction. They get the same injunction that the debtor would get. So they are done. They never, ever, ever have to hear the words Diocese of Santa Fe again if they don't want to underwrite it. So that's a huge plus for the mediator to move towards that goalpost. And it's a huge mediator for all. So let me spend 4 or 5 more minutes. I see the time's going quickly. Let me talk about some of the normal topics that you've all talked about before, but with this kind of slant on it. First of all, the choice of mediator. And, look, I think that there's always this issue of should it be aggressive mediator with aggressive personality, which I tend to mean not strong arming, just aggressive, forceful. Is it low key? That's a much more subtle term. And to me, low key means the art of listening, the art of explaining weaknesses without alienating the party you're talking to. Most importantly, a mediator that can read the room, that has legitimate eye contact, that is able to understand. So to me, those are choices that can vary in any case by subject matter, by nature of the case. What is different in the bankruptcies, and I think we've developed this over the years, and it is changing much more in the direction of private mediators. I think the first case I did was the Diocese of Spokane, 2004, so over 20 years ago. And the mediator in that case was an acting bankruptcy judge, Greg Zive, out in Nevada, who came up to Eastern Washington. They're allowed to do that with approval from the sitting bankruptcy judge. So here you got a sitting bankruptcy judge, a real judge. You still have to call him Your Honor, even if that's not what you're inclined to do, who happens to be having dinner with the acting judge in the case. Oh, they're not going to talk about the case. They're not going to do that. But they're having the 3-hour dinner. And that was the model for a couple of years. And I will say it was very effective because my view is bankruptcy kind of hovers over everything. Insurance issues are critical. Tort issues are critical. But in the end, it's a bankruptcy, and you need someone that appreciates that. That began to change, though. We got retired bankruptcy lawyers who went into the business, and and retired bankruptcy judges who are private now. I find that a little bit more challenging because those former judges tend to forget they are not presently a judge, and they need more patience than they had as a judge. They need more tact than they had as a judge. But we still have many of those in the complex in the cases, and they're very good. I mean, I'm not knocking them at all. And then there are private mediators who have begun to come into the cases. Often they started as a second mediator to the bankruptcy mediator. So bring in an insurance specialist or a tort specialist, right? And now we've gotten to the point where most of these cases have 1 or 2 or 3 mediators in them. Not all, but many. And then the third characteristic, which is extremely unfortunate, is in most of the cases, we are now on our 3rd, 4th set of mediators. We just concluded the Rochester bankruptcy, and so I can talk about what's public there. Successful resolution was mediated. First mediation started in the fall of 2019. We concluded early this year. So over 40 sessions of mediations, 1, 2, 3, ended with our 4th mediator. Not because of unsuccessful mediations, my view, and it's not because of fresh start. Everybody talks about a fresh start. My view is everybody was exhausted. Everybody had tested the limits. Everybody believed what the other side was saying, and those cases resolved. A little bit about opening statements in that context. Largely unhelpful because the mediation in these cases are going to last at least a year, probably 3 years. And so if you gave an opening statement, you forgot it probably by the 3rd session. I do think joint sessions occasionally are very helpful to come back in for half an hour, have coffee again together, kind of calm down any anger that has occurred so far, but not really advocacy. And the same with respect to mediation statements. Let me kind of close on that, and Jeff, you can give me any questions. Mediation statements here are extremely important, and I want to give you my theory of mediation statement, which is I never, no matter what the limit the mediator gives me, I never go past 10 pages. And I want it to be 90% helpful for the mediator. So, and maybe 10% advocacy, but mediators, as sharp as everybody on this call, spot that. What I mean by helpful, I mean accurate summaries. How many claims? It's the brief that I want them to have on their desk to continue to go back to no matter what the issue. How many claims? What was the nature of the abuse? How severe was the abuse? What insurance policy years did it fall into? Maybe a little bit on the 2 or 3 big insurance issues that will dictate the outcome of this case, but not really advocacy. Here's the law, here's what it says, here's where we're weak, here's where we're strong. And then ultimately a matrix of some sort, but again, a graph, a diagram that will help the mediator understand potential risks. And I will say that's been extremely helpful. One thing I'm kind of proud of is what we've done on that without using an outside vendor. And many mediators have asked me to, and indeed, I guess this is the ultimate a compliment. One of the insurance companies in a recent case their lawyers asked me to give that matrix presentation to the client. So very helpful. So the last thing I would say, in all of these difficult cases, as everybody in the call knows, probably anything wise about pretty much anything in the universe, but especially law, comes from Bob Dylan. And you see up here, that's the 1974 Dylan concert out in Seattle, along with Robbie Robertson. And he sang, of course, like a Rolling Stone. And he was talking in part about mediations because he said, you know, you'd never compromise with the mystery tramp, but now you realize he's not selling any alibis. And you stare into the vacuum of his eyes and you say, do you want to make a deal? And that's where we go in some of these complex cases. At the end of the day, we've stared into the eyes and there's nothing left. So Jeff, I've gone too long, I think.
Not too long at all, Jim. It's a wonderful presentation. And of course, the reference to Bob Dylan and like a Rolling Stone. So when you're in frustrating moments in these mediations, Jim, how does it feel?
Well, I'm never on my own. Look,
and you're certainly not a complete unknown. Everybody knows who you are. So
yeah, sometimes I am to the mediator. So it is a matter of not assuming anything, Jeff.
So let's zero in on some of the things you've discussed. First, to the extent you're able to talk about this without violating any confidentiality, you've seen scores of mediators in these diocese cases, these very complex cases. What are some things that stick out in your mind as particularly effective things that you've seen mediators do and particularly ineffective things that you've seen mediators do?
Yeah, it's a great question. And over the course of those 17, 18 cases, 20 years, there's a lot of variations. And there's no, I can't think of anything that was totally successful, totally just unsuccessful. But I think the failures tend to be, again, failure to read the room. And by that, I don't mean just the room they're presently in, but all of the parties. Where's somebody bluffing? Where are they real? And I think, for example, I think one weakness I really saw in a case was a private mediator who just went too hard at the client, not too soon, just too hard. And once you get a bad taste in your mouth, it's very, very hard to get it out. And not too hard on the substance. See, this is it. Not too hard on the substantive issue. If you're talking about this lost profit exclusion and say, Murray, you're an XYZ jurisdiction, you're going to lose it. There's a Supreme Court case in that state. Get real. That's not it. But when you talk to the client about you got to come to this number, period, no reason, and that it's happened a couple of times. That's a personality of someone from a particular area of the country where that. If he was talking to somebody else from that country, area of the country, it wouldn't be a big deal. My wife's Italian from New York. And, we have different styles, and I've come to appreciate when she's yelling at me, she doesn't really mean it. And so that's one. On the flip side, I think on the most successful side, I've seen someone who clearly is knowledgeable, clearly knows the area, but doesn't hold it over the lawyers and continues to listen. And it's very effective. And if you're not a sitting bankruptcy judge, there's nothing you do about it right now. But to be able to say, I really had this issue last week, here's how I would rule on it. Not saying another judge wouldn't have, but this is how I would have ruled. And, please take that into account. Very, very, very effective. But I would say in the end, patience. In the old days, these cases lasted about 2 years. Buffalo now is in its 5th year. Syracuse just settled, but it was in its 6th year. If you don't have patience as a mediator, it's a lost cause. And if you tick off even one party, and you get the reputation as, pro plaintiff or pro debtor or whatever, it can be the kiss of death. So that's a real challenge for the mediators in these cases.
So there are times, Jim, when we do have to get evaluative, and you drew the critical distinction between actually being able to put meat on the bones and talk about why it is that you think an argument may have merit or not, versus just the person who's exhorting settlement for settlement's sake, and nobody likes to engage in unprincipled compromise like that. People want reasons, but mediators always walk a fine line between being evaluative and breaking bad news to people who are not particularly eager to have it, and developing that kind of antagonism where you become evaluative with somebody and they say, oh, well, he came down hard on us, we're the policyholders, he's pro-carrier.
Yeah.
What advice do you have to mediators to be able to break the bad news that lawyers want us to break to their clients with the lawyer's help, but avoid getting the bum rap of being labeled as a non-neutral or partisan mediator?
Yeah, no, it's a real question. And here's my bottom line answer is I tend to believe still in human nature that the difference in us and animals is that we're rational. And I think if a good lawyer and ultimately a good client, if a good lawyer is faced with a merit-based argument, and they are pushed by the mediator and that they will understand it. And I'll give you I'll come back to the question, a quick example. I think I can talk about it because it's 20 years old, it's public, and I think Judge I've told this story publicly. So in the first Spokane mediation, the number of occurrences issue in all of these cases, right, still governs because these historical policies had occurrence limits, but they had no aggregate for these types of cases. And so the issue is, what's the occurrence? There's $300,000 per occurrence. Insurance industry in the early days said, well, the occurrence is, say, the Archbishop's one-time oversight of his flock that year. So here's your $300,000, go away. policy doesn't define occurrence in this way. So we say, look, we think it's each instance of abuse. If a kid is abused in January and again in December, sure feels like a separate occurrence. And so those are 1,400, that's $900 million. You're at 300,000, we're at 900 million, let's compromise. In a state jurisdiction where that issue is not resolved, sometimes it has to be fought about. And in the case in Duluth, the insurance company stuck at 900,000. They had 3 years of 300,000. My number was kind of artificial because at that point it was irrelevant. And Judge Zive said, as much as I hate to do this, parties and Jim in particular, I don't think it's going to crack. I think you need to spend the next 6 months getting this issue at least partially resolved, and we'll come back in 6 months. So in front of the bankruptcy court, we filed partial summary judgment on a number of occurrences. We won, but it was a bankruptcy judge. There was appeal to the district judge. It could be appeal all the way up, but it was enough to bring that insurance company to the table, and it ended up paying, instead of 900,000, 15 million, which was not 900 million, but it was a reasonable number that in the end the committee was willing to accept as well. So those exceptions, Jeff, do happen. But I think, and this is another reason, when I get a new case, I would much rather have a really, really good law firm and lawyer for the insurance company. There's a few exceptions in terms of personalities, but generally I would like that because they appreciate the merits, right? And they know where to fight, where to dig, where to compromise. And in the context of a mediation, especially if there are good lawyers involved, I think outside of the client, you can talk to that lawyer, and it might not be the first day, and it might have to go back to home office. But in the end, merits will matter. The substance matters. And that's what I could say. I think you can pound the table harder on the merits than on give me more money.
Yeah. Jim, you talk about these multiple days. Most mediators will tell you it's a rare circumstance where several consecutive days of mediation is really warranted. In these cases, do you find that you're scheduling mediations for a whole week or several days at a time, or are they more sprinkled over the calendar? How do you plan that so that time is used efficiently and productively?
It's a great question, and it's not intuitive because the answer is largely not the same as in a normal mediation. So rarely are more than 2 days or maybe 3 days, but often 2 days is the norm, depending on at what stage. You're coming back. You're coming back with different constituents. The mediator might call just the insurance companies and the debtor back. They might call just the tort committee back. And so it's a moving puzzle, but they're so complex is the right word, but they're also so emotional for everybody that frequently days in between are productive. Now, I think it's important, and the good mediators keep schedules. I mean, you schedule it 3 or 4 months out, but 1 or 2 days at a time. And that's the way I think if you kept people there for 5, 6 days running, you would make no more progress than you would. Unfortunately, you just got to get used. And this is a client expectation issue. I mean, when I talk to the bishop or the head of the company, this is going to test your patience unlike anything you ever done before, and it's going to be many, many years. And that goes, Jeff, I think I know everybody's thought about the difference in Zoom and in person, and I'm a huge supporter of in person. I think much more gets done in the hallway and in the bathrooms and outside in the old days smoking a cigarette than gets done in the room. So there's no question on that. I think Zoom has a role here in keeping people connected. So say particularly in the Archdiocese of Agana. So for me, that was a 13-hour flight to Japan and then a 4-hour flight down to Guam. And so there, when we scheduled mediations, it was for the full 5 days of the week. And in one of the early experiences we had, one of the parties, and I won't name it, but one of the parties walked out of the mediation on the morning of the second day. You had 30, 40 people had flown to Guam. And now that had a reverse effect because the next time the mediator did certain things to make clear that wouldn't happen again. But in the meantime, in between those sessions, we had multiple Zoom sessions. And that was a matter of keeping in touch, obviously during COVID. But even now, I mean, we have Zoom sessions in between the in-persons, but everybody kind of knows that the Zoom session, unless it's at the very end, closing the gap between 31 and 32 million, Zoom sessions only have that role, Jeff. So yeah, no, it's a daunting task to enter into a mediation when you know you got at least 2-3 years of it left. As a trial lawyer,
Yeah.
it's like I say, I'm a trial lawyer. I hate mediations, but by definition, pretty much all I'm doing lately.
Yeah, well, Jim, there's one prominent lawyer who told me he'd never hire me again because I helped him settle a case he was so eager and almost desperate to take to trial. He said,
Yeah.
"Nah, I'm not going to you again. I just want to take these cases to trial." And
Yeah, I
so,
don't take that. I wouldn't do that to you because the client can see through that. So it's
right, right. So, Jim, let's talk about the joint sessions. You commented on that briefly. It's a hot topic in the world of mediation. What are your views in general, and are there differences in these kinds of cases as opposed to a case where there may be a lot of money at stake, but it's just one policy holder and one tower of coverage, and the issue is one occurrence or two?
yeah, it's a good. So in general, I mean, I think in these cases in particular, again, there's a little bit of different slant. In general, I like the joint sessions. I believe are useful to keep people semi-friendly. A 20-minute session to touch base, etc. But it is extremely dangerous in these contexts to have a joint session where anything on the merits is discussed. So let me give you an example. I mean, if you did that, you would have in the same room 8 different insurance companies. One was a jerk, one was wanting to settle, and then everything in between. You would have the tort committee, which is looking at the bankruptcy angles, but in the end, their client is the group of victims. In the last 6-7 years, you have many of the tort lawyers in there who want desperately to try these cases, who are not at all happy that there's even a bankruptcy, right? And then you have the debtor, and you have the parishes. Within the debtor, there's many different stakeholders. One of the most important things in these mediations is not monetary, it's the non-monetary considerations for, rules regarding sexual abuse going forward and reporting and all that kind of thing, extremely important to parts of the stakeholders. And then, of course, the parishes, it's now public in many of the cases that have settled that the largest contribution to the ultimate pot that everybody takes or pays is often by the parishes, not the diocese. So even parishes that have no claims against them. And again, I'm not saying anything that's private because some of the ones that are resolved are public. And so to talk in a room full of everybody, here's one issue that is volatile, and you'll understand why. You have 400 claims. What's the value of the claim, somebody asks. So I've come to the point where I will not use the word value in this context. It makes no sense. The only objective truth on these claims is a verdict. Now, a verdict, yeah, that's a value, and that's the reason they're in bankruptcy. And we can guess whether the verdict would be 5 or 10 or 20 or $50 million. But the reason we're in bankruptcy is to not go there. So that value is it's not irrelevant in the discussion. And then there's, Diocese of Helena settled for $40,000 a claim. So that's not a value either. Diocese of Helena had no insurance. They sold it back. They had very little. They sold it back in the early 2000s, and they had about $1 million left in the bank to even keep the heat on. I mean, the bankruptcy. Yeah, I shouldn't say anymore. It was very difficult. It was not relevant. To me, the value of these cases is what the parties settle for, and that's why it goes back to the mediator. It's what the plaintiff will take. It's what the debtor in combination with the third parties can give. And that's the value of these cases. And it varies in every issue. And that's one related topic, as opposed to what I told you about in Duluth, where we had to try that issue. I tried desperately to convince everybody to keep all, but certainly the biggest issues on the table, to not file a motion in the bankruptcy court. The carrier took this position on XYZ exclusion, bam, I file an adversary proceeding and immediately try to get it resolved. It seems to me, well, I know this to be the case. Number one, bankruptcy court decides, it goes up to district court, and you might lose. You might win, you might lose. But it doesn't incentivize anybody. What incentivizes people is knowing they have risk on the table.
Jim, let me ask you one more question before we devote a few minutes to questions from the audience. One issue that often comes up, you have the primary insurer, you have different levels of excess insurance, and there's somebody in the middle of that tower, some excess insurer, who just is drawing a hard line. They don't want to pay anything. And all the excess layers above that say, well, if they're not in, we're not in. And it can make everything just grind. It can grind things to a halt. What's effective in breaking that kind of logjam in a mediation?
Really important part of the equation in these contexts. Let me tell you why. Because you're right. I mean, the excess sits above $1 million, right? The excess is saying, as a matter of advocacy to the mediator, we're excess. This case would have to settle for over $1 million to even pay $1 by us. We'll throw in nuisance value. Yeah, we have a $5 million excess layer above the million, but it ain't ever going to hit. Good luck. That would be a bad lawyer and a bad excess carrier that took that position. So the only good thing about the chaos I've described to you with all of these different stakeholders involved is nobody knows where it's going. Remember what I said at the very beginning, there's only two resolutions. One, a mediation that's successful, or two, a dismissal of the bankruptcy where everything goes to hell and it gets litigated. So what encourages those excess to put in bigger dollars is that threat of dismissal. There's a middle ground I'll talk about for 2 seconds, but the threat of dismissal. So again, I can say it because it's public in Rochester and it's been discussed publicly. So in that case, one of the excess carriers, I don't remember the exact number, but they paid about $40–50 million. And theoretically, if you just looked at a fancy coverage chart, they would have to value each claim at over $2.5 million to pay that amount. They don't value that way. So why would they ever pay that amount? And they would tell you out of 200 cases, they're going to win 180 of them. Because the risk of a handful of them going to verdict and the verdict going way above their layer and certainly sucking up their layer, even if it's only 3 or 4 or 5, 6 cases out of the hundreds, puts them at severe risk. So that is a very reasonable claims handling business decision. And remember, what they're getting is a channeling injunction and a release. They never have to hear of us again. And so it's a real important. Now, some carriers, the XYZ company jerks, they will take advantage of that and say never, never, never. And often you end up taking a little bit less from them. I shouldn't even say that. But it's the truth. And so, but by and large, people want that injunction. Now, the middle ground I've described, and this is the plan that's being litigated in the confirmation hearing next week in New Orleans. The biggest carrier is sitting it out. And this is all public, it's all in motion. So there's a global resolution between everybody in the case, every stakeholder. the trustee has some objections, but the Travelers Company is not participating, and the plan has an assignment to the trust against Travelers. That's a middle ground. It's a whole nother 2-hour topic. But by and large, that has not been the context of those cases that have ultimately resolved. That's frequently been on the table. It was on the table in a couple cases. At the end of the proverbial day, the outlying carrier settled the night before confirmation. So, but basically, that's the pressure, Jeff, is that if the case gets dismissed, it's chaos for the next 15 years for everybody.
In the few minutes we have left, Gene, let me ask you first, if you have any questions. You spent many years working at very high levels on behalf of insurance carriers, and you know a lot about this stuff. Do you have any questions or points you'd like to add?
It's so true what you say. I was on the insurer side primarily, and the same kinds of things, wanting to get cases settled. With the bad faith cases, where you have to have extra contractual exposure for that. What do you see in terms of cases where, for example, the failure to settle cases where maybe the policy limits were offered early on or even before before lawsuit was filed, but after the deadline or the time period that the plaintiff attorney, the policyholder attorney, wanted to have it settled. And any comments or thoughts on that?
Yeah, I mean, Gene, it's a great question. It's a big question, and very quickly kind of give you the ranges, including in Chapter 11. So generally, in one-off cases, I love that risk. In terms of bad faith and failure to settle within limits, I really do like nuggets of fact that really speak to a jury. And in one case I had in Idaho, we got punitive damages on the bad faith. I asked for $9 million of punitives against the insurance company. The jury gave me 9.7. And I had lunch with the chairwoman, and she said, we just wanted to remind the insurance company what they could have settled for. So that's one extreme. In the context of bankruptcies, I don't find it very important. In fact, threat of bad faith or the words, just get everybody's back up and trying to get to that ultimate dollar with an insurance company, I think is not super useful unless there's some obvious fact that's unique to the case. In the middle ground, I will say that one thing that's probably even better than bad faith and easier to get is prejudgment interest. And in that arbitration case I told you about, I think the arbitrator forgot about the state we were in had 10% prejudgment interest. And at the end of the day, the award by the judge was the prejudgment interest award was larger than the policy limit.
I once had a policyholder lawyer tell me when we had a case going up to the California Supreme Court after different opinions at the trial, then the appellate, now we're going to the Supremes. And anyway, trying to settle it. And he said, 10% interest, that's the best investment I can make today. And they did get their ruling the way they wanted. So yeah, that was interesting settling that after the fact then.
It's 12% in Washington. So if anybody has a Washington case, be sure to send it my way.
Okay, it's Don here, Don Rose. Good to see you. Jim, thank you for your comments. I had a question. You mentioned early in your remarks about captive cases, and I just was wondering whether you see the dynamics in captive cases differently, and whether there are specific mediator approaches to those kinds of cases that you found to be significant or impactful.
That's a great question. And again, I'll preface it with, I haven't done too many captive cases, but I've done some. And, again, my favorite phrase, the old days. In the old days, the captive was there. It was part of the company. Frequently, the president of the company or of the insurance risk manager was head of the captive, blah, blah, blah. It was there to fulfill regulatory provisions. And usually it didn't have separate counsel, and usually it paid, and then it went to the excess or the reinsurer, depending on the facts. I will say what's changed really a lot, and you know this, in the last 3-4 years, is insurance companies have started demanding and making it part of their defenses. If you don't, separate counsel. Where's the coverage opinion? How did you do testing whether the captive really treated the claim at arm's length in the third-party way that an underlying CNA would have done? And so that's the new challenge. But I am happy to say I don't do too many captive cases, too difficult for me.
Jim Murray of Blank Rome, thank you so much for a most informative and instructive presentation on mediation and settlement and general handling of these very complex insurance coverage cases, the intersection of tort, insurance, and bankruptcy law. I hope that people are moved to contribute to Bread in the City in Washington, D.C. I know Natalie has posted the link in the comments. Or people are also welcome to contribute to whatever food bank in their own community or one that's important to them. If people would be kind enough to let us know about their contributions, send us an email. We would be delighted to add it to our running total. Jim Murray, thank you so much. And with that, we are complete.